Chapter 3, Legal Issues, Part 7. Just a few words. We're going to be talking about the Fifth Amendment, but just a few words more about pretext stops. I'm trying to keep each of these PowerPoints to 15 minutes max, and we were right at the limit, so that's why I stopped in the last one. But if we go back to the last PowerPoint, we were talking about pretext stops. Your book actually calls them pretextual stops, but most people just call them pretext stops. A pretext stop is essentially a stop where the police are looking for something that's criminal. They suspect that a person may be up to criminal activity, but they don't have the probable cause to stop the person for that activity. So they find some other minor traffic violation, and they pull the person over for that minor traffic violation, hoping that when they go up to the driver and take a look, glance around the inside of the car or talk to the driver, whatever it might be, that they'll find evidence that will lead them to the bigger crime. So where this is done most often is with DUI, drunk driving enforcement. You know, what often happens, and maybe this has even happened to you, it's 2 o'clock on a weekend night, 2 in the morning, the bars have just closed, and let's say you're driving on Penn State campus. Well, at each stop sign there's a white line that's drawn there, and let's say you make a stop, but your front wheels go 6 inches past the line. So you still made a pretty good stop, but technically you have not made a valid stop. You're supposed to stop before the white line, not after it. And so a police officer happens to be there, sees that you went over the line by 6 inches, and then pulls you over. Now, do you think police officers really care if you go 6 inches over the white line and still make a good stop otherwise? No, they're never going to pull you over any other time. But why might that police officer pull you over at 2 o'clock in the morning on a weekend night on a college campus for a minor violation? Because they want to check you out. That officer wants to get up to your car, listen to you talk. Are you slurring your words? Can he or she smell alcohol on your breath? Or is there any other evidence of drunk driving? Now, they had no probable cause to pull you over for drunk driving. They didn't observe you swerving. They didn't observe any other problems driving. All they saw was a minor violation, but they used that as a pretext stop to justify checking you out a little bit more further, basically with plain view searches. So smelling, hearing, seeing, any of these kinds of things. And so police officers will tell you this is how they get a lot of their DUIs. They will pull people over, and if the person checks out and there's nothing wrong, they're not drunk, nothing like that, the police officer is likely to say, have a nice day, be more careful about that stop. If the person does smell of alcohol or give any other indication, then the police are going to give them a sobriety test and see if they can get them for DUI. There was a state college police officer who held the record for the most DUI arrests in Pennsylvania, and then it was broken by a University of Scranton police officer, and it may have been broken by somebody else since, but those officers were interviewed for a newspaper article, and they both said, we use pretext stops. Well, we might say that that's okay for DUIs, but pretext stops, as we'll talk about when we cover racial profiling, can often hide racial profiling, and that's something I said at the very end of the last lesson. They often hide racial profiling because, you know, a police officer will tell you, the motor vehicle code is so expansive that I can pull you over for almost anything if I'm a police officer. If I follow you long enough, you'll go a couple miles over the speed limit. You'll maybe make a turn without signaling far enough in advance. You may have some problem with your car. Maybe you have your registration stickers on your license plate. And in Pennsylvania, before we did away with registration stickers, they had to be all displayed, actually only one each year displayed in the upper left-hand corner of your license plate. So if you put them in the left and the right and the bottom and all over your license plate, that was a violation. So if you had one in the left corner and one in the right corner, technically a police officer could pull you over for that. Maybe you have a proud Penn Stater license plate cover and it's covering up the state name. That's a violation. Maybe you have something hanging from your rear view mirror. So the police officers will tell you, I don't have to make anything up. I can find something to pull you over for if I follow you long enough. And then they can check you out more closely for, see if they can see anything inside your car. Maybe you'll consent to a search of your trunk, those kinds of things. And what we find is that sometimes we see a disproportionate number of stops, these pretext stops, of minority motorists than white motorists. And so we're going to talk about that more when we cover racial profiling. But that's what pretext stops are. The police officer uses some little violation to allow them to check you out for something bigger, and they can't directly pull you over for the bigger thing because they don't have a probable cause, so they use the little thing as an excuse to make the stop and to check you out further. And the Supreme Court in Wren permitted this, said this is all constitutional. We will not look at the motives of the police officers. This is fine. So that's pretext stops. Let's move from there to the Fifth Amendment. So we'll leave the Fourth Amendment for now. The Fifth Amendment has some important protections of protection against self-incrimination and due process, and we have protection for due process. Those aren't the only things that are in the Fifth Amendment, but you can see here I've edited the Fifth Amendment so that you can see the important clauses. So the self-incrimination clause says no person shall be compelled in any criminal case to be a witness against himself. So the government cannot force you to be a witness against yourself in any criminal case. Now in a civil case, yeah, you can be forced to testify, but if you think that that testimony can lead to criminal charges, you can take the Fifth, as we like to say, which means plead the Fifth Amendment, which means I refuse to testify because I don't want to incriminate myself, potentially incriminate myself. So defendants have an absolute right to remain silent at trial, and we'll find out that the court has said they have a right even before, during the investigative stage, during basically all stages of the criminal process, to remain silent. Then we also have this general clause that deals with due process. It says no person shall be deprived of life, liberty, or property without due process of law. We talked a little bit about that with the 14th Amendment. You see the same kind of clause, except it says no state shall deprive any person of life, liberty, or property without due process. So there are two due process clauses in the Constitution, one in the Fifth and one in the 14th. The 14th applies to the states. The Fifth applies directly to the federal government. But both basically say the government must follow criminal procedure, follow certain rules before they can take away your life, liberty, or property in a criminal case. And you also have due process protections in civil matters as well, but we're only interested in criminal matters in this class. One of the key cases that interpreted the self-incrimination clause, the right to remain silent, was Escobedo versus Illinois, and that was in 1964. So this is one of those due process revolution era cases. And in Escobedo, Danny Escobedo's family was involved in a crime, and that his brother-in-law was shot and killed. And police suspected that Danny was the person who killed him. But it wasn't entirely clear, so they asked Danny, and Danny refused to admit to anything. A second suspect, who was a friend of Escobedo's, was brought in by the police, and he did admit to being involved in the shooting, but he claimed that it was Escobedo who actually pulled the trigger and fired the fatal shots. The police brought Escobedo again into custody. This was in Chicago. So the Chicago police brought Escobedo into custody, but they interrogated him but didn't formally charge him. Escobedo knew some of his rights, and he said that he wanted to speak to his attorney while he's being interrogated, or before he answered any questions. His attorney actually even at one point showed up at the police station, but Escobedo's request was denied by the police, and his attorney, who had asked to speak to his client, was also refused access to his client. So Escobedo was questioned without being able to consult his attorney, and during this interrogation he eventually said words to the effect that he was there at the shooting, but he didn't pull the trigger, it was the other guy. Well, that basically made him as guilty as if he did pull the trigger. So the police were able to get this, in essence, a confession out of him to involvement in the crime that condemned him as much as if he had admitted that he had pulled the trigger. Escobedo then appealed and said that this was a violation of both his Sixth Amendment right to an attorney and his right to remain silent. The U.S. Supreme Court, even though it seems like a right to an attorney case, really focused on the Fifth Amendment aspect of it and said that it really involved his right to remain silent. And what the Supreme Court said was that custodial interrogation is a critical stage in the criminal process. So what we mean by custodial interrogation is when the police take you into custody and interrogate you. That could be at the police station, but it could be out on the streets if you're in custody. And what we mean by custody is a reasonable person would believe they're not free to go. And so if you are in custodial interrogation, if custodial questioning is taken, this is a critical stage. And so this is a time when certain rights accrue. So interrogation is an important stage in the process, and defendants have rights. The court then went on to say that when a suspect requests to speak to their attorney, and this is during custodial interrogation, that is tantamount to the person saying, "I wish to remain silent." So what the suspect is basically announcing is, I'm not capable of making these decisions for myself. I want the help of an attorney, and therefore I don't want to answer any more questions, so I speak to my attorney. So the Supreme Court said that when a suspect asks for their attorney during interrogation, all questioning must stop. It is the equivalent of asking to remain silent, or not asking, asserting that they wish to remain silent. Now this was followed up in 1966 by the famous Miranda case. In Miranda, Ernesto Miranda was suspected of some crimes, kidnapping and rape. He was taken into interrogation. The police, taken into custody, I should say, so the custodial interrogation started, and he was interrogated for 2 hours in police custody. He initially denied that he was involved in the crimes, but eventually the police got him to write a statement in which he confessed to the crimes, and he signed off on the statement saying it was true. The police never told him that he had the right to speak to an attorney or right to remain silent during this process. So Escobedo had said that you have rights during interrogation, but they didn't say that the police had to actually tell you about these rights. Well, Miranda changed all that. The Supreme Court said, if we rely on the ignorance of criminal defendants and suspects to get our confessions, then this isn't really a system worth saving. We shouldn't be afraid of those constitutional rights that were written into the very fabric of our government back in 1791. Instead, we should embrace them and advise suspects that they have these rights. Then if we get a confession, we know we can probably trust it. If somebody knows that they don't have to speak but they still do, then we're more likely to trust what the police have done. We're not saying, well, that was really trickery. This suspect wasn't too smart, or maybe they didn't understand English very well, or they didn't understand the system very well, or whatever it might have been. So if we make it clear that they don't have to speak, that they have a right to an attorney, and they still confess, then we're more likely to trust that it might not have been a wise decision, but they made a decision on their own with proper information. So Miranda says before starting custodial questioning, and I have that in bold because it has to be custodial questioning. That means you are in custody being questioned, hence custodial questioning. You've got to probably figure that out for yourself. But you are not free to go. You must answer the police questions. At that point, then, the police must advise you of certain rights. If the police officer just comes up to you, as you're walking down the street and says, "Hey, how's it going?" and you say, "Not bad, except I'm a little tired because I just killed a few people last night and I was spending the whole night burying them." Well, you can't say, "Haha, gotcha, you didn't read my Miranda warnings." No, that wasn't custodial questioning. That was just, you volunteered that information. But if you're in custody, the police must tell you before interrogation, you have the right to remain silent. You have the right to an attorney. So you've heard all these things in a television show. And if you waive those rights, as we see on a typical card, most police will carry this or have it memorized. You have the right to remain silent. If you waive that right to remain silent, anything that you say can be held against you. You have the right to an attorney. If you can't afford one, the state will provide one for you. And so if you start answering questions, you want to stop, you can do that as well. And so the suspects are now advised of all of these rights before custodial questioning commences. And so the two main rights are right to remain silent, right to an attorney.